but right now we have a closed audience. So you feel free if you don't want something to be there or recorded, you can say, and then we will edit it. In principle, we have here all the students from our research group on compliance from our masters in law here at Facamp. Faculdades Campinas is a university that is located in Campinas, a little bit away from São Paulo, about 2 hours away. And I'm here with my colleague, Professor José Antonio Pontes, who is a coordinator of this research group together with myself and Professor Fábio. And since this is the first panel of our conference, this is our third conference on compliance, I'll give him the mic so that he can make the introductions for the whole Congress.
Thank you, Professor Karin. Good morning, everyone. Good afternoon. Good evening in Russia and Italy, I believe in India. And welcome, everybody. You are very welcome to our third international meeting. The third international meeting on corporate integrity and global legal regulation, which is a very broad name to put all you in comfortable ways to develop many topics of our research. I would like to thank specifically this panel for the coordination with us from Professor Elizaveta Gromova from South Ural State University in Chelyabinsk. I don't know if I spelled correctly and if I speaking correctly, but it's a very important support for us. Professor Elizaveta has already been with us in the first meeting, and we're on the third edition, and we expect to have lots of topics, new topics on the frontiers of our researching challenges. Which one of you have a nice and wonderful meeting. I'd like to welcome two part of our students here are from Colombia, from education for one of our coordinators too, which is Professor Mendieta Gonzalez from Medellin. And so welcome too. And we expect to have time in the end of the panel for a chat and asking question and answers, and to change your impressions among everyone who's panelists and participants in general. Thank you. I'll give the word back to Professor Karin and wish you success in this first panel. Thank you, everybody.
Thank you, Professor Zé. It's a pleasure to be here with you. We are colleagues from the law school, so it has been many years of a successful partnership. A few years ago. So, we were thinking, Elizaveta and myself, on making the presentations and in the following sequence. If you have something against it, you can say. We'll start with Professor Chiara, and then we'll go to Professor Garima. Then we can go to Professor Daniel, and then Professor Diego, if you are okay. Our intention is to have about 20 minutes presentations from all of you, and maybe at the end, we can make discussions and reply to some questions that one may have to the other, that we here at the panel have, or the students also have. Are you okay with that? Okay. Yes. So, obeying the order of invitation, I will invite Elizaveta to introduce Professor Chiara.
Yes, dear colleagues, first of all, my sincere apologies for for the delay. It is totally my fault. I just came back from business trip, so I guess that is why something wrong with my head. So please excuse me, and thank you so much for this amazing panel, for organization. I will try my best to contribute and not to do anything bad anymore. And of course, I'm very glad that my dear friend from Italy, dear Chiara, Professor Chiara, renowned expert in artificial intelligence, found the opportunity to join us today. So, dear Chiara, I can't wait to listen to your keynote.
Thank you so much. I will share my screen. Please let me know if you can see it. First of all, thank you so much for the invitation. I'm really happy to be here. Can you see the slides?
Yes.
Okay. So, first of all, I would like to share that today I will talk as part of my Marie Curie project about the reuse of health data, in particular reproductive data, for AI training, and in particular in the light of the new regulations that were enacted in the European Union, the AI Act and the European Data Space. So, can you see the second slide? I hope so.
Yes.
Okay, great. So, as I said, this presentation is part of my Marie Curie project, which is funded by the European Union. However, my views and opinions does not necessarily aligns with those of my funders or the European Union. So it's totally my opinion. And my project has started last year in July at the University of Turin, Italy, and it's called a new European framework for an ethical reuse of health data. So first of all, I would like to introduce the topic of using AI in reproductive healthcare. So what is AI in this domain? Those are very high-tech technologies based on artificial intelligence models, so models that have a certain degree of autonomy and are trained on data, on patient data, which are very useful actually for patient care because they help with in vitro fertilization and with fertility diagnostic and in general for women health care. So with these technologies, based on the training data of women, they can teach the algorithm to recognize certain disease or certain features. For example, with this technology, it is possible to improve the survival of embryos and to improve the chances of a pregnancy, because the AI algorithm can learn which pictures of the embryos are probably better for the outcome of the pregnancy and can suggest to the doctor a certain treatment or can tell the patient if there are slight chances. So the treatment decision can change based on this suggestion. So it's useful in some way. There are a lot of clinics now based on these technologies all over the world, actually, and they are really expensive. So it has been estimated that in some countries, the treatment for IVF could be about 200% of GDP per person. So you see that it's a very, very expensive solution, although it might be even effective. So how does these models actually work? Why do they need this amount of data? Why are we concerned with the reuse of health data? This because artificial intelligence has a lot of application with data. So in machine learning, which is one kind of AI, you use a large amount of data to teach the AI to solve a certain problem. For example, they can use CT scans to recognize a certain disease. They make connection, learn from the data, and find patterns between the different data. For example, medical images, but not only images, also physiological values, elements from previous disease, like the anamnesis of the patient or heart rate, in general, all the information related to health. This can be done with unsupervised learning. So you feed the data directly to the model, and the model learns from just the data, or supervised learning, where the data are labeled by a human, likely a doctor. For example, a doctor might put labels on MRI scans and tell, this picture is of a healthy patient, this picture is from a patient that is not healthy, or label the specific disease that is in the picture. So to function, many AI systems need data, and the quality of data influence the quality of result. So for companies, and in particular health companies, companies that are based on health of patients, their business model is to help patients feel better. For them, the quality of data and the quantity of data is very important. For them, data is like gold. So they are very interested in having more data. But there are also some problems with AI, because if there are biases in the data, this means that the model will not learn correctly. So the European Union took these concerns into consideration while enacting the Artificial Intelligence Regulation, which is called the AI Act. It's a new regulation that was just approved this summer, and has provisions to mitigate AI biases. And in order to mitigate these biases, they thought that all data processes were to be controlled and had some requirements and obligations for AI providers to how the data were going to be processed. So they had this very long list of requirements, like, for example, risk assessment, quality management, and such, and specifically related to data governance. So now AI providers are permitted and even encouraged to use health data in order to mitigate biases or even remove biases. So if an AI provider has only a few data from a specific population, for example, white people, they are allowed to integrate the data set with a diverse sample of data, so they can collect more data, more health data, in order to train their model and make the model more accurate and less discriminatory, at least in principle. So under this new provision, actually, these fertility clinics that needs their data to improve the model are allowed to harvest data from patients and use it to improve the model. And although there are some safeguards in these provisions, those safeguards are not, in my opinion, enough to protect the interests and rights of patients. To add complexity to this legal framework on artificial intelligence, the European Union enacted another important regulation, which is called the European Health Data Space. Under this new regulation, a new infrastructure for health data has been created. It's a European infrastructure shared across Europe, in which data from patients will have to be uploaded in this new system, which of course must be secured by data protection also provisions and technical standards for safety and security. But in this new framework for the sharing of health data, the access to health data will be much easier. So, for example, if I go to France from Italy, the French doctor will be able to read all my health data in their system with my consent, but still the data is shared. And there are a lot of options in which my consent is not needed. For example, for public interest or pandemics, like we know during COVID, in the future, public institutions for the public interest, they will allow to access my data without my consent. So, when you share this large amount of data across many different countries and many different people, the risk for patient increase. So, in addition to these primary care provisions, there are also provisions for secondary use. Not only the doctors will be allowed to access our data, but also researchers, public institutions, and companies in the European Union and abroad will be able to ask for a permit, an authorization to reuse such data for a number of uses, like developing new products and also training AI. So you see, this legal framework has changed dramatically. But if we look at this new legal framework with the lens of critical data theories, we see that there might be a problem. So I consider following some philosophical theories from Kitchen and Loriot, Michel Foucault and Gramsci and Ian Hacking, that data sets are data assemblage. This means that the data for the AI, the ontologies that are inserted into data sets, are shaped by those who construct them. And women with fertility issues are already in a vulnerable situation with respect to doctors, because those doctors have, their lives in their hands, they have their future family in their hands. So there is a problem for a country with a very long colonial history if the doctors, how often happens, belong to the dominant group. For example, the wealthy colonizing society or other dominant group, very popular groups like white males. And patients, on the other hand, belongs to the minority, like, for example, people coming from the ex-invaded territories, what they were called the ex-colonies, because there is a power imbalance. And we can see that every day if we look closely to how these people are treated in our society. So another layer of discrimination adds up, because the person collecting the data and the person manipulating this data and deciding what data goes into AI, to what degree and in what form, these people are from the dominant culture. and the patient have little say in this process. So when we talk about the AI biases, there is really a risk. So there is a problem because you know that companies want to make profit, of course, and they need this data. So what they will do, they will have questionable data practices. They might go to, I don't know, Africa or other countries where fertility clinics, high-tech fertility clinics are very expensive and offer their services for free or for a very cheap services. This is already happening in other industries where high-tech companies offer their products for free in exchange for data. So what will happen is that these companies will be allowed to harvest the data with little transparency, because the transparency obligations in the European law are limited by some provisions. For example, they can avoid giving certain informations on their product, like AI, if this information are classified as trade secrets. So reproductive data might be used not only without the consent, but also without any notice. And all this data then will finish in this new European infrastructure. So I was wondering, is this a new form of colonialism, of data colonialism? Because we have data exploitation. So just like once the colonial powers extracted the materials from the invaded territories, now these high-tech companies extract data from vulnerable individual, marginalized individual, without transparency or accountability. And this is like mirroring past inequalities and exploitation. And then there is another risk, eugenics, because this dominant culture will be able to decide through their system who will be born, you know, the embryos that will be more viable or in their opinion, better to survive, and who will be discarded. So I don't know, I think this practice is very problematic and has a lot of ethical issues. So in conclusion, I think that there is a problem in the new legal framework, and we really need to pay attention to the data practices to avoid perpetuating or amplifying the inequalities that are already present in our society. So what we can do as legal scholars and people influencing policy: understand, for example, that AI datasets are not objectives. Data is not born in a vacuum, but it is a product of societal norms. Review our legislation and apply post-colonial lens, critical lens, to the analysis of our legislation to avoid increasing the risk of exploitation. And then regulate the market so that these exploitative practices are not allowed, and take into consideration the opinion and the risks for marginalized groups. So I thank you for your attention. I hope this talk was interesting and that I give some food for thought.
Thank you.
Thank you so much.
Thank you so much, dear Chiara. As usual, it was very interesting and informative. Thank you so much.
Indeed, very, very interesting. Thank you so much, Professor Chiara. Elizaveta, I think the next is also with you, and then we leave the questions for the end. Is everybody okay, the panelists, with that? Okay.
Yeah, and now I'm also honored to give the word to my another friend, this time from India, to Professor Garima Tiwari. And I'm also happy to say that she's not only from India, as she's also a postdoc fellow in my university, South Ural State University. So, dear Garima, the floor is yours.
Thank you so much, Professor Elizaveta, and I think it's an honor to be present here. I thought that the first presentation was actually something that would help me in developing my topic also. What I would be talking about today is a general overview of how we see artificial intelligence use with the lens of international human rights law. Also, because if you see Indian regulations and how India is growing right now, we have come up with a lot of laws pertaining to evidence right now, which has created a lot of extraterritoriality and included the involvement of digital evidence in the country. So when this happened, there was a lot of discussion as to how AI and human rights will play a role, because the amount of diversity that is there in India might lead to problems with, imagine 22 languages which are there in our constitution itself as designated languages. How do you really take those languages, feed something in the AI system, and then to be able to use the evidence? So while I would be discussing that maybe through the questions that we have, I thought to initiate, I will have a general discussion on how AI has been used or discussed in international human rights law. And we know that as we have reviewed a lot of information and what was presented even now, AI tools have actually led to, they can actually process vast amount of data, and it is easier for people to detect patterns of human rights violations. For example, it can even analyze satellite images to identify evidence of mass atrocity or environmental violations in remote areas. In addition, if you see, it has also been reviewed in light of predicting conflicts, disasters, famines, and how we could give timely response. Now, while I'm talking about all of this, we might, as was discussed, that we're discussing it in light of those countries which are trying to develop their laws post-colonization, and also the countries which have tried to come up with views which are like third world approaches to international law, if you would have heard of those. So there is also this whole understanding of how international law is growing. So in this slide, AI-driven tools, when they are chatbots or online platforms, while they can assist a lot of individuals in accessing legal services, it is also important to see what kind of legal counsel is being given to them through these particular models. Now, we know that Amnesty International used AI to analyze the satellite images and also to see the evidence in Darfur and also in Syria. It also tried to see how the patterns were there regarding destruction, displacement, which was actually going unnoticed at one point. So human rights abuses could be seen through the lens of AI. And even for human trafficking, for example. Now, all of these are certain offenses which might now have to be seen through the Indian criminal law lens also, because now that you've created, so usually what you will see when you're studying Indian legislations, the word that is written is this law applies to whole of India. So they have removed this word so as to understand that there are lots of documents, evidences that might now come in, which are fluid in nature, which might come in from other countries. So, for example, matters pertaining to human trafficking also, where you have to then detect online human trafficking activities through suspicious online behaviors and advertisements. So a lot of training is required for people using different language patterns, different cultural understandings of what is actually right and wrong. Now, criminal justice and also predictive policing, we know that it is being used in a lot of countries where they're trying to predict, crime hotspots, to say, based on historical data. However, this has also raised concerns of bias and discrimination, as you will see that you might, and like the previous presentation pointed out, that you might have certain marginalized communities being targeted. So you might disproportionately target minority communities. So if you see, India also has several communities which are minority, and there are several religions, different caste discriminations that are there in the country. So this might also lead to certain types of biases in predictive policing. As we can see in US also, when predictive policing tools were used, there was a lot of criticism regarding it perpetuating racial biases. There was also the discussion in India pertaining to facial recognition technology. And that was very interesting because you have to now understand that people, and interestingly, India also gave a decision some years back where it said that we will have right to privacy as a fundamental right. So you see the dichotomy here, because you have right to privacy on one hand, and then you have created all of these AI models without really training anybody in the country in understanding a lot of things as to what could be taken. This also, the problem is also coming from the fact that there is a huge digital divide in the country. So with the disparity, some people may not even have a phone, but they might be going through, let's say, a transport system, or they might be just traveling somewhere and their picture would be captured, and they might not even understand how it has been done. So this huge digital divide leads to a lot of problems. So this is another issue that comes up with how the laws have changed in the country, and particularly when you try to see the implications of it as to how human rights, so you continue to sign a lot of treaties, you try to bring in a lot of laws, but then how it impacts the country and individuals specifically, because the laws apply even to the person who is there in a small village in a country, who is probably an illiterate woman who may have never been exposed to any kind of technological system at all. So then when you're bringing in facial recognition technology and you're advancing all of these things in the country, I think it leads to a lot of problems. So for example, if you see in China, how facial recognition technology was used to monitor the Uyghur Muslim communities, and it was raised that how they were able to discuss about mass surveillance and oppression. How could it become a tool in the long run is also to be seen. Of course, there has to be human rights laws that are to be created in this process. Social media, again, advancing at a stage that I think all of us have access to it. And we see that it is used to, in a way, direct a lot of opinions in the country. And it also leads to AI is being used to moderate content on platforms, Facebook and Twitter, the aggregation that happens, the aggregator tools that are being used. So while it does help to flag hate speech, there could be disinformation and harmful content that still flows. There are also problems in certain situations where there are issues and there are riots or conflict zones where there is over-censoring of information, free expression. And that also is happening because of how it is being used. So, and in authoritarian regimes, we know how it could censor political dissent. So it could also be a problem. We know about the Great Firewall of China also, for that matter. So I think that is something that requires attention from a human rights perspective as well. There's also this discussion about the drones and robots being used, killer robots, and the way the armies are being trained today. It has also led to a lot of ethical debates about how it would be used. And I'm taking this as an example because the current evidence law that has been brought today in the country, it has allowed for the court-martial, that is the way the army act, the way army soldiers would be tried. So there are special laws in the country, how they are tried. So now they have allowed for this evidence law, which was usually for civilians in the country, to be applicable to them as well. So this is a new change that has been brought with this law. So this is again being flagged that when you're trying to bring in certain laws, so you may have discussions about Common Article 3, you may discuss about Common Article 4, and you have all of these discussions on one hand from human rights perspective, You're creating a national legislation that is now creating fluidity, and it is now applicable to certain autonomous systems and drones and technologies developing. So that's one. On military applications, I wanted to flag that issue. And we're facing, I think, the issue of refugees. I think that's a issue that is everywhere. And in India also, we had the Rohingya refugees trying to find a safe place. And India has not ratified the Refugee Convention. It has also not ratified the Torture Convention, for that matter. And so we rely mostly on policies that come up regularly. And there are good policies that have come up. So we mostly do take in refugees, but again, it has to follow certain rules and regulations that are changing as per each group that tries to find a safe place. And the word refugee is not used in the country. Mostly you will find migrants, because there's no law that deals with refugees. So the normal criminal law applies, normal passport and documents law applies to them. So again, here, UNHCR, as we know, it has also explored the use of AI to provide aid to refugees. They've tried to bring certain concepts in the country as well, so that they can predict the movements and also enable a better planning. They've also developed, if you've known, the project Jetson, which is there to predict patterns of refugee migration. So how such systems could be used in the country now is to be seen. So largely, if you see, these biases could be put forth in terms of bias, or these challenges could be put forth in broad categories of bias and discrimination on one hand, because you have the training on historical data for a lot of these human rights issues, which definitely in these precise issues could lead to historical bias, because you're bringing in a very specific data to train the system. And then, like I said, the language issues that we're going to encounter, I can tell you that there's hardly any people in the country who would, particularly in rural areas, who would be speaking English. They might not even speak Hindi, the language that I usually speak. They have a very, very different dialect. You move from one state or city to the other state, you will find a different dialect. So that is one issue. Privacy violations, I've already flagged, and also the use of force. So the regulatory challenges that are there, while you're changing the law, you're coming up with the new laws. International human rights law, why we have signed UDHR, ICCPR, ICSCR, we have come up with our own Protection of Human Rights Act in the country. It has still not really created certain binding frameworks in this regard. We largely feel that there is a regulatory vacuum because we're still learning about AI and its implications. So I think we don't have a law that really regulates international or human rights violations, for that matter. We don't know what to do about it. We're coming up with specific issues and then we're trying to regulate those, particularly because AI is going to be cross-border. It's not going to be something which is going to be limited in a country. So it makes it very difficult for a single jurisdiction to regulate it effectively. That's why probably we would need something of an international document here. Even if it is not universal as of now, it could be based on international cooperation and agreements. So you can ensure that the developments are more aligned with the standards of human rights. And so you can see there is a policy and legal shortfall in this regime. There is also a sort of a stakeholder shortfall because we're not really taking into account everyone when AI is growing and law is being discussed, because there's a kind of there's a group that is going to be affected by it who might be actual victims in the process, who are not being looked into really and not being involved in the process. And of course, the technological shortfall, because like I said, there is a huge digital divide. So while the UN and AI ethics report exists today, they've taken a step towards it. UNESCO's recommendation on the ethics of AI is there. There are human rights impact assessments where companies and governments are being encouraged to evaluate the potential human rights impact on AI before they are being deployed. And there are also efforts being made in this regard, but I believe that this is required from a broader lens and not particularly, because even regional if impact of it might be seen if you are taking up something in a one place, but the impact of it is very large scale. For issues of fertility, like was discussed, for issues of surrogacy for that matter, issues of trafficking, everything gets connected in the large run and then longer run, and you'll find that it might have certain implications. So I just wanted to flag certain issues right now and probably seek answers here as to what could be done in this regard, where people are doing their research, but it requires a discussion that is more in line with something that would be required for countries that are exploring models of AI and human rights, because we know that there will be issues of algorithmic transparency, there'll be issues of cybersecurity vulnerabilities, unfairness, bias, legal personhood issues that we are seeing, lack of contestability issues, and the diversity that is there in all of these laws. To what extent can we really look into this? And we might therefore need an analysis from the frame of probably vulnerability, so that you try to see how AI could be dealing with this. So I think I'll conclude by saying that we really need a robust framework to ensure that AI is used responsibly. And while laws are being developed in different countries, but we have to see that they adhere to the international human rights standards. And it's a challenge, I think, for the global community to ensure that this AI development is consistent with the human rights values, because we have reached we have reached very far in discussing human rights as a field in itself. Now, with the emergence of AI, we are back to certain issues of legal personhood, who is a victim in this regard, how AI is going to impact people. So I think we really need to see how AI on one hand, law and the dignity and rights of all individuals is secured in the process. So I'll leave it here, but I really look forward to having a discussion and see what could be done and how we as scholars can really work out something in this regard. Thank you so much.
Thank you so much, dear Garima, for this very interesting keynote. I hope you also will have a time to stay and wait for the questions, because I'm sure we will have some. Thank you so much again.
Thank you. Thank you so much.
Thank you very much as well, Garima. Very interesting, and we already have questions for you here, so I really hope you can wait, and Professor Chiara as well. So as next, I would like to invite a good friend, Professor Daniel Branches. Professor Daniel, he is very interested on adequate dispute resolution methods. He works as arbitrator and mediator in several centers. He's also a professor of law in the Law School for Judges in the state of Rio de Janeiro, and also at the Masters of Law at Umbra University. In the US, he's a research fellow at the Bowdy Center for Law and Social Policy of the SUNY Buffalo Law School, and he is chief editor of some important and relevant law journals, like, for example, the Brazilian Magazine for Alternative Dispute Resolution, which is Scopus Index, and the International Journal of Law in a Changing World. Daniel is going to talk to us about arbitration and artificial intelligence, and the floor is yours, Daniel. Thank you very much for joining us.
Minha grande amiga Karin, obrigado pelo convite, após aquele nosso almoço em São Paulo, sempre uma honra te encontrar. Agradecendo a todos os brasileiros, todos da Facamp, também primeiramente pelo grandioso seminário. And my dear friend Elizaveta, which I just met in Russia. I had the opportunity to go to Russia right now. I came back to Brazil yesterday in a big forum in Kazan, and I could see there that they are discussing the same issues that we are discussing here in Brazil and actually worldwide, and especially digital technologies. They have huge forums in digital technology and law, so also in other matters. So it's important for us to discuss. And just sharing one quick thing, one quick data, I discovered that they retire in Russia with 45 years old. If you're a judge, you retire with 45 years old. And in Brazil, I just told Elizaveta that we are reaching like retirement with 250 years old or something like that, and they are increasing that. So, you know, I was amazed. But of course, they can keep working, but they get their full wage, their full salary of 45 years old, which is amazing. If we're discussing here previdentiary matters in Brazil, we're never going to retire. So just a quick thought about it. I don't know how is it in other countries. In India, for example, Garima could enlighten us, in Chiara in Italy, but in Brazil, we're just expanding this age. So it's not easy for us here. Let me share my PPT real quick. So I hope you can see it. Perfect. So this is my email here. If you want to reach me, please feel free. And I'm here to contribute and to help with no ego and all the modesty that, you know, anyone in the academia should have. So please feel free to reach me whenever you want. So when we're talking about arbitration and AI, and we need to talk a little bit about ODR, the online dispute resolution system. So if you are talking about the paper-based in-person types of dispute solution, we're talking about alternative dispute resolution, which some authors call adequate dispute resolution, because you need to choose the adequate door in the multi-door courthouse system. So, but if you move that to the online and use the use of technology, we're talking about online dispute resolution, ODRs. So, of course, there are three main procedures here, like procedures of agreement when we're talking about online mediation, procedures of advice when we're talking about tool supporting negotiation, and of course, at the end of the day, procedures of decision, mainly online arbitration. So what is arbitration? As we are talking here, addressing my speech to students mostly, arbitration could be compared to a platypus. And this is not my metaphor, it's Professor Carlos Carmona, a metaphor, a reputed professor from São Paulo. And because arbitration is not civil procedure. Arbitration looks like civil procedure, you know, it should appear like civil procedure, but it doesn't, for example, follows the civil procedure code of the Brazilian civil procedure code or the Russian civil procedure code, for example. It has its own set of procedural rules, usually the institutional rules. If you choose, for example, the arbitration to go through Kansas CBC in São Paulo, you will follow their procedural rules. So it's a main difference. You know, the civil procedure code applies only if the parties choose so. So parties' autonomy play a huge role here in arbitration. Of course, at first, they were the ones choosing arbitration instead of the judiciary system. So they chose arbitration because we're talking about negotiable rights. For example, moral damage cannot be ruled and decided by an arbitrator. That must go through the judiciary. But if you're talking about money and negotiable rights, you can actually pick arbitration according to the Brazilian law, the Brazilian Arbitration Act from 1996, Article 1st. So the main concerns when we use technology are the ones that actually develop that technology. So if you talk about arbitration and mediation, who developed, for example, an AI tool? So we need to see who was we call like the fourth party and the fifth party. The fourth party is the developer of the AI. Is actually the AI, the software per se, not only the AI, but a software that's being used. And the fifth party is the designer. So for example, the software, the AI or whatever, it cannot be culturally biased. You know, just a quick example here. If I'm using a software developed by the Indians, the Indian culture is a lot different than the Brazilian culture. So that could give us some problems, you know, because the AI tool can actually be biased. I'm just giving you a quick example. I was using a tool to check my English, a tool called Grammarly. You know, Grammarly is a software where you check your English, you put it there, it gives you suggestions to correct your English or whatever. And for example, I was writing with Professor Elizaveta a paper on unmanned vehicles. Unmanned vehicles, which is the legal term for drones and unmanned. vehicles. So the tool actually suggested me, you should use uncrewed vehicles, because if you're using unmanned vehicles, it means you are excluding other people, but it's the law term. It's not an exclusionary term. So, you know, of course, when it excludes, you should change it, but to be more, you know, more open for it. But otherwise, you know, there was cultural bias. It was wrong, actually, because the legal term is not that. But, you know, problems of confidentiality in proper cybersecurity software are also an issue here, because when we're talking about arbitration, confidentiality is a big issue. So the parties choose to go to arbitration mainly. One of the key features, commercial features here, is confidentiality. So using software and putting all the data there, and you don't actually know who's gonna be able to access it, where it's gonna go. So it's a serious problem here. And of course, we need to address the AI and the predictive and automated justice versus the need for flexibility. And, you know, automated justice is not well regarded in the arbitration, in the ADR ecosystem, because one of the key features here in arbitration is the ability, the capacity that the parties have to choose the judge, to choose the private judge, you know, by looking at its qualities, its skills, his qualities. So if you have just a software deciding for you, that wouldn't be, that would be actually against the nature of arbitration. Another thing, if you are practicing putting AI and video conference softwares who can actually, for example, Zoom, it can read the facial expressions, and other softwares are video software already applying AI too. So if you are an arbitrator, a serious arbitrator, you want to go to in complex disputes, you want to go to a hearing in person. So that wouldn't help you, and you cannot let yourself, you must read the person, the witness, the parties by yourself, so the experts by yourself. You cannot rely on AI to read the facial features, for example, for you. And being in person, cross-examination in the hearing is very important if you have the skills for it. So, you know, the media effect, the literature talks about the media effect. So the more technology you use, the more psychologically distant you are from the person, from the witness. So of course, for simple cases, that's okay, but not for complex cases. So that's why, you know, I like this meta model, and which is based on the Mehabarian and Ferris formula from 1967. You know, Mehabarian says that, you know, only 7% of the language is verbal, 38% is you know, the 38%, 38% is the voice tone, and 55% is the body language per se. So you have to, if it's a complex dispute, face-to-face or a hearing, they are actually a key issue for the arbitrator to decide, because at the end of the day, what plays a key role in your decision is the evidence. So you need to, and witness is important evidence here in arbitration. So, you know, you have to know how to use the movement and environment in your favor to adduce, to analyze, assess the evidence in a proper manner. So what are the main features here in arbitration that are widely known? It's a cost-effective procedure. Of course, it should be, if the parties don't play against it, don't practice guerrilla tactics. So it should be a cost-effective procedure. But if you use AI or software, it would be even more cost-effective. But I have some doubts about the actual effectiveness of the decisions, because, you know, when the parties, they go to arbitration, all they want is an enforceable decision. So your main responsibility as an arbitrator is to render an enforceable decision, especially when you're talking about international arbitration, when you have two countries, companies from two different countries involved, and the seat is a third neutral place. So, you know, you have to take care about this effectiveness concept. It's a speedy procedure, usually In Brazil, it lasts like 20 months for complex disputes, so it's a lot more. It has a lot more speed than the judiciary, the state courts, and parties can appoint their arbitrators. And usually the parties currently are using AI and softwares to do what we call profiling. So they check the profile of the arbitrators, what the arbitrator has published and what is his actually personal profile, and before appointing an arbitrator to their dispute. And I was amazed because recently I was in a conference here in Brazil, and suddenly a lady approached me and says, "Hi there, I'm from an investigation company." And I was, "What do you mean by investigation company?" She said, "I can investigate anyone. We investigate anyone you want. I'll just give you hand you a dossier with all the information, and I don't care what you do with that information." So what did she mean about that? She was meaning that she investigates arbitrators. So, you know, in order to assess if there are any conflicts and if the arbitrator is actually failing the duty to disclose. So that's where we are at currently at the arbitration community. So arbitrators are being investigated at the end of the day. And if you compare that to AI, it becomes really hard because you cannot, you know, message the AI and say, "Please disclose your conflicts." And the AI, of course, would never do it. And the duty to disclose is a key factor here in arbitration. And of course, a party could ask for the software company of the AI to disclose all the algorithms, but you have to hire like an expert to assess those algorithms if it's biased or not. You know, I'm talking about an automated decision, so it's kind of hard to do that. And in Brazil, for example, arbitration is being well practiced for high-profile clients. So we're talking about high-profile disputes, like complex disputes with a high amount of in dispute here, high-value disputes. So, for example, in China, they use arbitration a lot more for mass disputes. So that if the disputes are simple, AI could be better applied. But in complex disputes like we have here in Brazil, at least in the big centers, you know, that shouldn't be applied. But should I say that AI is completely useless for arbitration? Of course not. Not for the parties, not for an arbitrator. So, for example, for legal research, you know, we have LexNexis, and you can use it and it's useful for legal research, for selecting experts, counsel, and arbitrators. For example, you have a website called JusMundi. JusMundi, they are all present here. They're always present here in the Brazilian conferences, and they have a conflict checker AI tool. So you put the arbitrator name there, and you will check. You will give if there are any possible conflicts, interest conflicts. So it's pretty useful for the parties before appointing the arbitrator. So, of course, AI tools for translation, transcribing, summarizing evidence, for e-discovery, for example, because the evidence is mainly digital currently. And myself, I've been publishing a lot of papers with Professor Elizaveta about digital evidence. And that's really important. E-discovery, you are actually looking in a huge amount of documents and data what you want. So AI could play a key role here in summarizing and get exactly what you want to use as an evidence in e-discovery. So, of course, they can use for tools of predictive justice, judge analytics, for example. Not much, you know, this is for arbitrations, not that useful because decisions are mainly confidential. But of course, like I mentioned before, you have the JusMundi, for example. It has a lot of arbitrations awards. They are available for you. And if you go for investment arbitration at EHDS, for example, in Washington, they're all, the decisions are usually all there. So you could use in certain areas, certain fields, predictive justice. We're talking about you know, analyzing the decisions and for trying to forecast the next arbitrator's decision. So I have a paper on this topic about judge analytics and jurimetria, jurimetrics, it's a big topic here. It was, for example, forbidden in France. The judges that didn't like that the people were actually use algorithm and AI to analyze their potential bias. So it's an important trending topic currently. So AI and arbitration, you can use analytical tools, arbitrary analytical tools, and of course, you can use artificial intelligence applications to replace arbitrators. So that's also an important factor here. And so what I'm telling here is that AI is important to assist human arbitrators and to assist lawyers, but not to decide the disputes. That should be tailor-made by an arbitrator who is actually assessing all the evidence thoroughly. So, machine learning also plays a difficult role in arbitration, because if most decisions are confidential, how can you put data? And you would also have to input very specific data. Like I said before, the Civil Procedure Code doesn't apply to the arbitration decisions. The rules that will be applied in that certain dispute will be chosen by the party. So you would have to input data for each dispute. So that makes machine learning even harder. So that's also a key barrier, I would say, in the use of AI in arbitration. So the question here is arbitration resilient to AI? I would say that for an automatic decision, for like a robot deciding the whole dispute, yes, but not for helping the parties and not for other uses that should be really useful. And arbitrators and lawyers should get used to it as soon as they can. So to summarize my speech here, this Hubbard quote is actually gives us all the picture. One machine can do the work of 50 ordinary men. So when we're talking about simple cases, yeah, AI could be useful to handle an award, to analyze the data and everything, document-based arbitration. It could be useful, but no machine can do the work of one extraordinary man. And when we're talking about the best arbitrators, they are really extraordinary men that have a high sensitivity in evidence assessment and in reading the whole picture of the case. So, and this is what the parties want in big disputes: extraordinary men deciding the picture. So deciding the case. So that's where we are at right now. So thanks a lot, Karin, once again. Thanks a lot, everyone. And I'll be here for questions afterwards.
Thank you very much, Daniel. So let's strive to be extraordinary men and women and never lose our jobs in working with law. And I did a terrible mistake. I forgot to tell that Elizaveta is also a good friend of yours, so she could have introduced you as well. I'm sorry, Elizaveta, I didn't even
Come
think.
on, we're on the bricks, Karin, so I can introduce by anyone. Come on.
Okay. So as next, I'm very glad to introduce you to Professor Diego Machado. He's a new professor here to our conference and also to our research group. But I'm very happy that he accepted our invitation. Professor Diego, he's an assistant law professor at the University of Viçosa in Minas Gerais. And he is an enthusiast about technologies and data protection and technologies and personal data. He's also a consultant to the Brazilian Authority on Data Protection, ANPD, and he demonstrates interest in talking to us about risks of AI systems and its regulation. I'm very happy to have you here with us, Diego. Thank you very much for accepting the invitation, and the floor is yours.
Thank you, Professor Karin. Hi everyone, and I would like to kick off with a few words in English before I turn to Portuguese. It's an honor to be here taking part in this conference. I'm very very grateful, and thank you, Professor, especially thank you, Professor Karin, for reaching out to me. And I thought that I'm kind of embarrassed of deciding to speak in Portuguese, and I prepared my presentation in Portuguese. But as most of the audience are Portuguese speakers, I decided to be giving my presentation in Portuguese. I hope this won't be
Don't
an
be
issue.
embarrassed, Professor Diego. We talked about this, and I said you were free to choose, and we have lots of students here speaking Portuguese. It will be very welcome, and we can talk about the questions in English or something like this later on. We thank you for
Yeah.
being the only speaker in Portuguese, actually.
Yeah, I mean, and even though I'll be giving my speak and my talking in Portuguese, I'll be happy to address any questions or provide clarifications in English if needed. No problems. So, turning to Portuguese, sorry.
Diego, português é melhor. Portuguese is the best language. Don't worry. I'm kidding.
Então, eu vou falar sobre regulação de riscos, né, em inteligência artificial. E a minha ideia é falar sobre esse tema. A princípio é mais por uma abordagem descritiva e não muito, né, avaliativa, vou trazer algumas considerações avaliativas, mas é mais talvez como um diagnóstico também. Considerando que há quase que um certo consenso de que quando se fala de regulação de sistemas de inteligência artificial, a abordagem de risco, né, ela se mostra como talvez a mais adequada ou é a mais proposta, né, seja os setores da academia, os setores né, entre reguladores, governo e também o próprio setor privado, enfim. E várias importantes, né, regulações, elas adotaram uma abordagem baseada em riscos, como, por exemplo, a gente tem o Artificial Intelligence, NIST, Artificial Intelligence Risk Management Framework, que é um modelo, né, norte-americano, que essa organização de padronização, né, o NIST, eles lançaram, uma abordagem, na verdade, que seria aí algo talvez mais próximo de um tipo de autorregulação, porque a sua adoção ela é voluntária, né? Não é uma regulação, né, vinculante. Mas temos também, como foi falado pela professora Chiara, o EU AI Act, que ele também é uma regulação de sistemas de inteligência artificial realmente vinculante, né, baseada em riscos. A própria GDPR, né, e a LGPD, influenciada por ela, também seguem lógica ou tem ali instrumentos de regulação de risco. Então, assim, a ideia é com base na análise de algumas, e o meu foco vai ser em duas, né? Dois marcos normativos. Na verdade, um é um marco normativo, a Lei Geral de Proteção de Dados brasileira, e um outro é uma proposta de lei, que é o PL, Projeto de Lei 2338, que está atualmente em discussão no Congresso Nacional. Bom, e a partir então da análise, né, de ambos aqui, como disse, algumas considerações, né, acho que também descritivas, mas talvez alguns aspectos interessantes aí de o que está adiante, eu gostaria de compartilhar também com vocês. Bom, por que uma regulação baseada em riscos, né? Assim, quais são os argumentos ou vantagens de se adotar uma regulação baseada em riscos quando a gente fala de regulação de sistemas de inteligência artificial? alguns argumentos aqui, pelo menos 3 argumentos que a gente encontra entre autores, né? Então, entre especialistas, e você vai encontrar muitos desses argumentos reproduzidos também em outros setores. Bom, o primeiro deles é que a gente pode dizer que muitos prejuízos dos danos que são decorrentes, né, de sistemas de inteligência artificial, inclusive alguns deles assim tocados aqui na primeira e na segunda fala, né, então a gente está falando de violações ou de riscos à saúde, riscos de discriminação, ou violações de direitos humanos, como por exemplo a própria privacidade, como foi ressaltado aqui. Esses, assim, muitas das vezes, esses danos, eles são latentes, são difusos e que se manifestam de uma forma, muitas vezes, assim, agregada. Basta a gente, assim, pensar nas diversas violações à privacidade que a gente vê noticiada quase que diariamente, envolvendo incidentes de segurança. Essas violações, elas ainda que de imediato elas podem não ter algum tipo de repercussão, às vezes, né, assim, direta, e que o cidadão, a pessoa, ela sinta essa repercussão direta, mas assim, há como que uma agregação, né, desses efeitos que, dado o conjunto de dados, por exemplo, que foram vazados de uma pessoa, ao longo dos anos, lá na frente, no futuro, ela pode sofrer, enfim, prejuízos ou danos muito significativos em razão desses danos que se acumularam, né? Essas violações que se acumularam ao longo, né, do tempo. E também muito semelhante a essa lógica de incidentes, assim, de segurança, existem algumas esses danos decorrentes de sistemas de IA, assim, são externalidades que, sem uma regulação apropriada, não teriam incentivo de serem internalizados pelos desenvolvedores, pelos agentes de inteligência artificial. Então, esse é um primeiro argumento. Um segundo é que regulações baseadas em risco, elas se apresentam, no mais das vezes, como regulações ex ante. Então, é uma regulação baseada em riscos, ela olha para o futuro. Ela está olhando, então, para o futuro, buscando, na verdade, se antecipar a ocorrência de muitos desses prejuízos e danos para fins de evitá-lo, né? Ou evitá-los, né? Há aqui uma certa lógica, né, de prevenção de danos, de lesão a direitos, interesses protegidos, né? E essa é uma dimensão bastante, na verdade, coletiva, porque você não olha, a princípio, para o indivíduo, você olha, então, para uma coletividade que você vai, portanto, proteger ou vai evitar, né, que danos se ocorram ou se materializem em relação a esses sujeitos. E um outro aspecto aqui também, que essa regulação ex ante ela possui, é que a gente busca influenciar ou, de alguma forma, né, orientar ou dirigir o desenvolvimento ou design de sistemas de inteligência artificial, a fim de que, sim, a gente evite, né, a maior medida possível a concretização desses danos e prejuízos. O terceiro e último argumento que eu colocaria aqui é que os riscos que esses sistemas de inteligência artificial eles causam, né, eles geram, eles são semelhantes a alguns ou análogos a alguns riscos a direitos e interesses difusos e coletivos que a gente já conhece, como por exemplo, a gente pensa aqui no campo da direito ambiental, no campo, né, dos interesses da regulação, voltada ao campo do meio ambiente e saúde pública, né? Então, a própria também segurança do consumidor, existem algumas semelhanças aí presentes, né? E não à toa que, né, vários, enfim, especialistas e autores, eles acabam sugerindo para lidar com os riscos de sistemas de inteligência artificial, mecanismos, né, que são próprios dessa abordagem. Eu vou falar um pouco mais de alguns desses mecanismos mais à frente. Bom, dito isso, se são argumentos, então, a favor de se adotar uma abordagem de riscos, isso não, assim, a gente não fecha os olhos aqui para os grandes, enormes desafios de se regular sistemas de inteligência artificial, né? A gente pode aqui listar uma série deles. A alta complexidade da cadeia produtiva de IA, né? Todos os atores envolvidos. E aí, quando você pensa, por exemplo, em modelos fundacionais abertos, né? Esses modelos generativos, por exemplo, de IA generativa open source, que está disponível para toda pessoa, enfim, todo mundo poder utilizar e às vezes construir desenvolver alguma aplicação já em cima desses sistemas, torna muito complexo você sim, regular isso. Também a opacidade, às vezes a incompreensibilidade de como é que esses sistemas funcionam, né? Principalmente a gente considera as redes neurais, os métodos de deep learning. Há também aqui um problema que é a diferença, né, a disparidade mesmo de expertise dos recursos humanos que a gente tem entre o setor privado e o setor público, entre o setor privado e a gente vai ter aqui até mesmo o regulador, né? Muitos dos maiores talentos e a maior capacitação, por exemplo, não estão necessariamente com ali aqueles atores, por exemplo, com os reguladores. Sim, é um desafio também de regulação da IA. E a própria, por fim, aqui um último desafio que posso colocar é assim, a imprevisibilidade não de quando, ou melhor, se vai acontecer, a imprevisibilidade da ocorrência, né, do risco. Na verdade, é certo que o dano, o prejuízo, isso vai acontecer. A questão é como isso vai se materializar, uma vez que esses sistemas eles são utilizados, são lançados, né, no seio social, como isso vai se concretizar, não há assim, um completo conhecimento, né? Tanto é que, quando a gente fala depois do chat GPT, começou a ter uma série de discussões sobre a ameaça existencial da raça humana e o surgimento de uma superinteligência, o que parece ainda pouco factível. Mas, bom, apesar de termos essa consciência, acho que é importante, até mesmo por esses desafios, a gente compreender a diversidade, a multiplicidade de instrumentos, de ferramentas, de mecanismos é, de, de regulação de risco existentes. Eu gosto muito de uma classificação proposta pela Margot Kaminsky, que é uma professora da Universidade de Colorado, e ela tem um artigo excelente sobre esse tema, e ela fala sobre três, né? Ela tem três categorias, então, de ferramentas e instrumentos de regulação de risco, que são, primeiro, táticas de precaução. Aqui a gente aplica uma lógica né, assim, it's better be safe than sorry. Então, se eu não conheço tenho dimensão de todos os riscos, as possibilidades de dano, é melhor é melhor ser mais cauteloso ou tomar medidas, né, de precaução de que desses riscos e violações venham a ocorrer. E aqui ela lista, por exemplo, algumas proibições legais, ou até mesmo tipo banimento de algumas tecnologias. Essa ideia, por exemplo, de banimento, ela ficou muito presente no campo, né, então, da inteligência artificial, por exemplo, nas discussões sobre reconhecimento facial, que surgiram uma série de iniciativas de banir essa tecnologia, o uso policial, por exemplo. E essa lógica, ela aparece em algumas leis, como o EHDS Act, então aí o clássico sistema que é banido, né, que é proibido assim, porque ele oferece um risco assim inaceitável, um sistema de risco social, um sistema como muitos apontam ser o caso, né, de existir na China. Então, esses sistemas de pontuação, né, sistemas de tipo crédito social, esse seria um tipo de sistema que todos os riscos que ele oferece, na verdade, são inaceitáveis, então eles devem ser proibidos. A gente também poderia pensar aqui em regime de licenças, né? Ela pensa em regimes de licenças como mecanismos de táticas de precaução e até mesmo os chamados sandboxes regulatórios, né? Que hoje, cada vez mais, eles ganham espaço na regulação de IA. Então, a ideia do sandbox regulatório eu vou chamar, convidar inovadores, pessoas que estão desenvolvendo um sistema de inteligência artificial, mas esse é um ambiente controlado, acompanhado pelo regulador, em que, caso, por exemplo, seja identificado risco excessivo de um determinado aplicação, aquele sandbox pode ser encerrado, por exemplo. Então, seria um mecanismo também, ao ver da Margot Kaminsky. Um segundo tipo, né, ou categoria, talvez a mais conhecida por nós, é a análise de risco e mitigação. Isso aqui, quem então trabalha com proteção de dados está acostumado quando fala aí sobre relatório de impacto da proteção de dados, né? A análise de impacto da proteção de dados. É um tipo de mecanismo em que os desenvolvedores, ou melhor, então, os agentes de tratamento, ou então os desenvolvedores de um sistema de inteligência artificial, eles vão fazer uma análise, uma avaliação de risco ali daquela tecnologia, aquele sistema que está sendo desenvolvido, e identificar os riscos, então, a direitos fundamentais, por exemplo, a privacidade, a não discriminação, esses riscos eles devem ser mitigados. E um terceiro e último tipo, né, categoria aí de ferramenta, são medidas pós-comercialização, após introdução no mercado de um sistema de inteligência artificial. E aí, pode ser, se tiver em curso um sistema de licença, revogação de licença, monitoramento pós-comercialização. Então, por exemplo, se mesmo após o lançamento, se criarem ou nascerem novos riscos, isso tem que ser avaliado, porque esses novos riscos surgem, devem ser mitigados, inclusive, devem ser, então, endereçados. Então, temos aí uma caixa de ferramentas com uma série, então, de instrumentos. É o que a gente precisa compreender quando falamos sobre a regulação de riscos. E, bom, olhando e tendo foco aqui na LGPD, que é uma lei vigente, em vigor, e uma proposta de lei, como é o caso do PL 2338, acho que vale a pena, então, a gente compreender assim, a diversidade de aplicação e de adoção mesmo desses mecanismos na abordagem regulatória. A Lei Geral de Proteção de Dados, ela sim é uma normativa de primeira ordem, inclusive aplicável a sistemas de inteligência artificial, que tratam dados pessoais, mas são aplicáveis a esses sistemas. E tem elementos aí de abordagem de risco. E o PL 2338, por sua vez, ele é assim, direcionado especificamente a sistemas de inteligência artificial. Ele tem um modelo realmente baseado em riscos. LGPD, então vamos primeiro olhar para a Lei Geral de Proteção de Dados. Como o risco aparece na Lei Geral de Proteção de Dados? Se a gente der uma olhada na LGPD, a gente vai identificar alguns usos, então, uma incidência do termo ou da palavra risco. E a gente vai encontrar, como por exemplo, um pressuposto necessário para a elaboração, né, do relatório de impacto da proteção de dados. Isso tem uma série de dispositivos. Logo, o artigo 5º tem o conceito de relatório de impacto. O artigo 38 também fala sobre. De forma interessante, o artigo 44 ele traz o risco como uma circunstância que ela é relevante para o juízo de irregularidade de tratamento de dado pessoal. Diz lá o artigo 44 que se o tratamento de dado pessoal ele não oferece os riscos que razoavelmente dele se espera, ele pode sim configurar um tipo de tratamento irregular. Temos ainda mais duas incidências que eu chamo a atenção, que é o risco como pressuposto para a comunicação de incidente de segurança ANPD. Isso está lá previsto no artigo 38, e até uma resolução desse ano da NPD, ela tratou sobre a comunicação de incidentes de segurança, né? Então, tipo, vazamento de dados, incidente de segurança. Tem ali o risco como um dos seus elementos. Quando oferecer um incidente de segurança, ele causar risco, diz lá o artigo 38, perdão, 48, deve haver a comunicação ANPD. E a quarta e última incidência da noção de risco é assim, que é um elemento que deve ser considerado, por exemplo, por agentes de tratamento, controladores, quando criarem códigos de conduta, quando fizerem regras, boas práticas e governança. Existem alguns códigos de conduta já emitidos em alguns setores, por exemplo, e entre os parâmetros que a Lei Geral de Proteção de Dados ela aponta, deve haver, temos aí a consideração de risco. Bom, para resumir, eu chamo a atenção principalmente para o relatório de impacto da proteção de dados e a obrigatoriedade de comunicação de incidentes de segurança. Porque aqui deixa claro que o conceito de risco na LGPD ele está relacionado a risco a liberdades civis direitos, e aos direitos fundamentais, para usar aí o termo da própria LGPD. Então, riscos a direitos fundamentais. É isso que a gente tem em consideração aqui. E aí, o último ponto que eu ressalto sobre a LGPD é que, muito embora existe sim essa abordagem de riscos, o modelo da LGPD é uma abordagem baseada em direitos, tanto que os titulares têm uma série de direitos previstos. O que a abordagem de risco faz, ela, na verdade, aí eu gosto dessa noção da professora Caterina Demetrio, é que ele é uma estratégia para incrementar ainda essa abordagem baseada em riscos. Ela não existe um conflito entre essas duas lógicas, essas duas abordagens. Então, a abordagem de risco, ela complementa a abordagem de direitos, né? Esses mecanismos de abordagem de riscos, eles, na verdade, incrementam essa lógica de tutela de direitos e dos titulares prevista na LGPD. Tanto é que o propósito, a noção de risco é risco a direitos e liberdades fundamentais. Então, a gente quer evitar que esses riscos ocorram. E, assim, o outro ponto, então, partindo agora para o PL 2338, e vou ser mais breve aqui, porque eu já vi que o meu tempo está estourado, mas essa proposta de lei, ela visa, então, regular sistemas de inteligência artificial e parte de um modelo de riscos que traz duas categorias principais. Risco excessivo e alto risco. O risco excessivo é aquele inaceitável. Então, sistemas de crédito social, como eu mencionei, e tem ali no artigo 13 outros exemplos também. Mas o foco principal aqui dessa lei é os sistemas de alto risco. Que são, eu tenho ali um rol no artigo 14, mas existem mecanismos para poder atualizar, que é algo muito importante, esse rol de sistemas que, por exemplo, sistema utilizado pelo Poder Judiciário para tomada de decisões judiciais, sistema de inteligência artificial que foi utilizado, por exemplo, no campo da educação. Nós temos ali, então, uma série de exemplos, né, de sistemas de alto risco. E o que eu gostaria de chamar a atenção primeiro, ele não é um sistema de licenças proposto, né? Cada agente de inteligência artificial, desenvolvedor, enfim, aplicador, ele vai fazer uma análise preliminar e ele vai fazer essa classificação de risco. É alto risco ou não? É alto risco ou é risco excessivo? Mas basicamente qualificar se vai ser alto risco ou não. Se qualificado como alto risco, tem uma série de obrigações, uma série de deveres que eles deverão observar, e eu vou ressaltar apenas 3 aqui. Uma série de direitos que devem ser observados: direito de explicação, contestação, supervisão. A avaliação de impacto algorítmico é obrigatória para os sistemas que forem considerados de alto risco, e também o risco ele aparece relevante como uma medida de, né, pós aí a introdução do sistema no lançamento no mercado, que é a possibilidade de responsabilização civil, tá? Mas, enfim, essa é uma discussão até maior, mas eu paro, assim, termino essa parte dizendo que o conceito de risco aqui, ele também se aproxima de risco a direitos e liberdades fundamentais. E o que eu concluo dizendo é que se a gente quer continuar considerando a abordagem de riscos relevante para a regulação de sistemas de IA, a gente precisa ter em mente a diversidade de ferramentas. A abordagem de risco, ela, assim, já é conciliada com a abordagem de direitos, a exemplo, por exemplo, da LGPD. E é importante também considerar e ter em mente e lembrar que a proteção de dados pessoais, ele é uma normativa de altíssima relevância para lidar com os riscos causados por sistemas de inteligência artificial. Obrigado e desculpa aí por estourar o tempo.
Muito obrigada, professor Diego. Muito interessante, muito importante, né? Essa análise aí da responsabilização e da mitigação de riscos, da regulação ex ante, e vamos voltar em breve aí para as perguntas e respostas. Elizaveta, shall we now open for discussion? I don't know if you would have any questions to Chiara. We have not received questions here so far, but students and from Colombia as well, if you want to ask something, please feel free.
We have questions as far as I can see.
Yes, Thiago has one. Please go ahead, Thiago.
Hello, everyone. Good morning, good afternoon, good evening. It's a pleasure to be here. First of all, I'd like to pay my respects to the entire team of Facamp, the professors, the students. It's always an honor to share my studies with you guys for some years now. And in addition, I would like to congratulate all the speakers on the excellent presentation, which will certainly support our studies within the research group. So let's move forward on my question. So Brazil is currently discussing the Bill 2338 that was already mentioned by Professor Diego, which aims to regulate the use of the artificial intelligence in our country. So some experts say that with the approval of a law regulating the matter, Brazil could reach a historical milestone that would establish a safe and ethical development environment in relation to technological innovation. So I believe that Professor Diego covered a lot of this in his presentation, but considering the scenario of a possible new law in our country, in the opinion of our speakers, what are the main risks and opportunities that our country should focus on, especially in relation to AI training, impacts of human rights, arbitration, which some of you may have already covered here, but I think that it's a great opportunity to hear about you, about your experience and within the international legislation. So thank you.
So whoever wants to start speaking, Professor Chiara, Diego, go ahead.
Yes.
Can I jump in? Go ahead.
Sorry.
Sorry.
Just add a small perspective on this is that the AI Act in Europe is taking a technocentric approach, which means that theoretically they think that if you really improve the AI model and the data set, all AI arms will go away I mean, that's the message that it's basically conveyed. Because they talked about a lot about AI ethics and trustworthy AI and such, but it's a known risk that data is not objective. Even if we base artificial intelligence on statistical models or mathematical models, it's not that linear. It's not that since you have data, then the result would be accurate and unbiased. So this approach, it's called technocentric, but there is another stream of thought that you find in the literature, that is the social model, the social technique approach. So what I would suggest, if possible, when discussing laws in other countries, is to take this approach into consideration, that there are risks also thinking that data are objective. Data are not objective at all. They can be interpreted and they can be manipulated and used in any harmful way that we can think about it. If we only check on accuracy of a model, on the other hand, you know what is AI accuracy? If you only give a positive example of a model, the accuracy will be 100%. If you only train the model with a healthy patient, it will be so accurate, 100% accurate in telling you that the patient is healthy, okay? But it won't be able to tell you if the patient is not healthy. So just pay attention to this supposed objectivity of AI and data. Thank you.
I will jump in and just, it's really interesting to hear Professor Chiara saying explaining for us this it's I think is a critical point, or what critics say about the AI Act. One of the points that they outline, at least you can find it in the literature, is that there's a problem there because we don't have any rights to the people affected. And the goal, the main goal of the EU AI Act, if I'm not wrong, is just, well, it's safety, it protects safety and fundamental rights. And I think that's one of the things, one of the issues that the committee of jurists, of experts that proposed this bill, the bill 2338, they acknowledge that we should have some rights to the individuals and to the people affected, not only individual but also the groups. And I think that, yeah, I think that's it's a good point. And in addition to that, I would like, maybe what I'm going to say connects with Professor Professor Grima.
Yes,
Garima.
Garima. Yes.
Sorry, Garima. In this intersection of AI and human rights law, that is the vulnerability, or the concept of vulnerability. These impacted, people, individuals, and groups. I think there's an opportunity to have a better understanding of the vulnerable groups or individuals through these lenses of risk. I think, yes, it is. Well, in Brazil, we're taking this risk-based approach, but we can use or explore a bit more the intersections or connections between risk and vulnerabilities. You know, how these systems not only aggravate vulnerabilities, but they create new vulnerabilities as well. So I think, yeah, it's an opportunity to better explore there.
Great. Any addings, Danielle? Garima, would you like to?
I think that very idea of vulnerability and risk was just discussed. And I think any law that is being made, so India does not have a law on AI. What we are doing here is largely taking the traditional or existing laws and moving it and trying to make it aligned with AI. So we do have information technology law. We do have some laws which deal with technology, but not specifically about AI. So I think when I'm studying AI in a country, like I pointed out, with such a diversity and so many issues, probably I will have to definitely discuss about vulnerabilities. I will have to discuss about risks. And I will also have to discuss about the reach of this particular technology to people, because it might just get limited to a certain group and create or further the digital divide. So I think how do you allow that to actually reach other people might also have to be seen, because how do you allow people to understand it? Because right now we ourselves are learning about it. We're discussing it when we are studying it. We know about certain models, but people might not at all be aware of it. So I think, again, awareness as a component has to be brought in with any law that is coming in. There has to be more training of the people. And I think a general awareness about the basics of AI or basics of what is happening in very simplified language might be needed for not just India, I think, but I think world over, because people might not know exactly what is happening. So that's just one observation.
Elizaveta, would you have any questions for Chiara? I have one if you don't have.
I actually have a question to Garima. It was interesting when you when you were talking about the problem with the refugees and how India uses artificial intelligence to predict migration and so on. And as far as I understand, you do not have any specific regulation, right? Or
So
India has something to regulate these issues.
So for refugees, India does not have any law. What we do is that whenever an issue arises, we use our judgments. So we have a common law system, but we also have certain regulations and policies that come in. So what we end up doing is that it goes through each government's policy. So you might see a trend in whether a government is okay with bringing in refugees or not okay. We also came up with a very interesting legislation, which was actually allowing people from a particular religious community only to be in India. And it was called the Citizenship Amendment Act. So it was passed by the legislature. It is still to be enforced. But then this law also somehow just said that only people who are of a particular religion or a particular group from certain countries would be allowed to take citizenship in India if they follow certain criteria, but it was a flexible, very reduced criteria as opposed to other. So no, we don't have a specific law dealing with refugees in the country. Yeah, so that is a problem, because then you don't even use the word refugee. You continuously bring them in the bracket of criminal law. And also then you might say that, they're without documents. And the fact that you've not signed the documents, the Refugee Convention or the protocol, then it just makes them, even to reach the offices of UNHCR, which are there in India, it's difficult for them. So that is something of a problem. Yes.
Oh, thank you.
Thank you.
Thank you very much. I would like to ask Professor Chiara. I was very intrigued by this EHDS. Is there an obligation of health providers to input the data there? And you were mentioning consent. Is consent the right legal basis for this? In the meaning, I mean, from my knowledge of data protection law, Brazilian data protection law, it's implicit in a consent that you can withdraw with. So how would a patient be able to withdraw the data that was inserted with his consent? And is this data inserted inside this EHDS anonymized, pseudonymized? Maybe you can bring more information for us because it's really
Indeed. Thank you for the very relevant question. Those are, in fact, some of the issues of the European Health Data Space, because citizens have the right to opt out, okay, but this right is limited, okay. So provided if you give the consent, the provider will put the data into the system. So the system is mandatory, okay, the infrastructure, because they want to promote a better healthcare across nations, because you know, with the globalization, a lot of citizens move toward the country, so they want to improve. But there are also some instances in which you cannot opt out. So basically, the legal basis is not consent anymore. It's called public interest. And to add this additional complexity is that, as you said, data could be pseudo-anonymized or anonymized. But if they are anonymized, under the European law, they become no longer personal data. So they are not covered by GDPR anymore. Okay. So the citizens have not the right to withdraw or to object and to whatever, because it's not for them, it's not considered personal data. I actually just wrote an article about this issue. And even if the data is not anonymized, when you put it into the AI and you train the AI model, how can you then go back and withdraw your consent or object to the use if the model is already trained, right? You should retrain the model completely without that single instance of the data. This is not really feasible. I mean, I think it won't happen. It just won't happen. So the provisions are problematic. Yeah, they have a lot of issues. So we need to explore this more and to investigate more this mechanism. Thank you.
great. Thank you very much. There's a question from Diego.
No, it's not really a question, because I was wondering when I was listening to Professor Chiara, and it just it struck me, because I mean there are very similar problems with, for example, the data scraping that, well, here in Brazil, I think maybe you've read in the news somewhere, we had this decision, these injunctions delivered by the Data Protection Authority a few months ago. Well, Meta had to stop training data using data of Brazilian users to train AI, because I mean all the problems related to data scraping, and I think we have an issue really similar. I mean, when if they train, then it's not an if, it's actually what they do, what they already have done. They train their models with data, personal data included, and what's now, right? If it's an illegal operation, I mean, the data processing is illegal data processing. What now? And also, I mean, there's a discussion, interesting discussion. The FTC, I think they have this model disgorgement discussion on how they like they ordered, I think, a few data provider AI, or I mean internet providers, to delete data, the illegal data that they have used to train AI. And there's the problem with the model, how they have to delete it. I mean, it's interesting. This is really interesting, this discussion. So it's just to share this, and to maybe it's more, you know, it's ongoing to put more food for thought, maybe.
Yeah, thank you. You are correct. I think there was FTC decision that they should also delete the model itself, because it was trained on illegally acquired data, if I remember correctly. Anyway, I also followed the discussion about the Twitter X in Brazil, right? That they were scraping data from Brazil, and I think that this use that large companies do of people's data are very exploitative, and it's very unethical to just use data without any consent and without any reward. And you cannot delete the data, and it has been shown actually in the technical research that in some cases you can even retrieve the original image or personal data, and specific personal data from the model, and they would restitute the output with your own data. So, for example, if you ask ChatGPT about some people, the name and surname of these people, they would just invent something not correct about them. It happened to a friend of mine that they asked, who is this person, and just made up some questions. Or some generative model with pictures, they just reconstructed the almost same exact face, the exact pictures of a woman. So it's even dangerous, right, from a data protection point of view. So yeah, I'm very concerned about these practices.
Very interesting. Having this in mind, I would like to ask a difficult question to Diego. For me, it's very difficult, but Diego, what do you think about the proposal that our Brazilian National Authority of Data Protection becomes the authority for the artificial intelligence system regulation in Brazil? Do you think this is a adequate possible decision or not? I mean, it's not fixed yet, but there are good chances, right?
I'll try to not be biased, but I think I'm already biased. I'm saying, just I think it's a disclaimer because I've took part in the group, the work group that analyzed, and I mean, and is working with these proposals related to the bill, the 2338. And I think it's I think ANPD is the Data Protection Authority is a good option. Not only, I mean, it's not because I'm working there currently. It's because I think in a regime that considers, I mean, rights, they afford rights to individuals and groups, and its goal is to protect fundamental rights. I do not think that other regulators are, trained or really have the knowledge and even the expertise to deal with risks to fundamental rights and freedoms. I know that, for example, the Data Protection Authority deals with the right to data protection. But, for example, I mentioned the data protection impact assessments in the Brazilian LGPD, and we have to consider risks not only to the fundamental rights protection of personal data, but also to other fundamental rights and freedoms. So that's and even I would say that's there's this legal mandate in Article 20 that is the provision regarding automated decision-making in the Brazilian law. There's a right to revision of automated decision-making. And there's a paragraph there that gives competence, this legal competence to the Data Protection Authority to audit systems or automated systems to regarding discriminatory effects, right? So, it's important points there, and I think it's an interesting. I think it's a proposal with the coordinating. Not all, the Data Protection Authority with all the regulators, sectoral regulators, and I think that would be a good option. But as I said, I also think that I should give this disclaimer. But the arguments that I would use for the DPA would be those.
Okay, interesting. Thank you very much. Elizaveta, would you have any question?
Well, yeah, actually, I have a question to Diego. Well, my Portuguese is not that good, so I couldn't understand that it all, but I found, I heard the term that is very much familiar to me, as it is the topic of my research, regulatory sandbox.
Oh, yeah, yes.
Yeah.
Oh, yeah. So go on, sorry.
No. So that is what I wanted to ask. So you were talking about the artificial regulatory sandbox to test artificial intelligence, right? So as here in Russia, we do have specific thematic regulatory sandbox that regulates artificial intelligence. And can you share Brazilian experience in this area?
Oh, sure. And it's interesting to know. I didn't know that the Russian authority had this specific authority to regulatory sandbox, right? It's very interesting, and maybe we could afterwards we could talk more a bit, because I am in this another work group with the Brazilian Data Protection Authority regulatory AI regulatory sandbox initiative, with this project actually that we plan to implement in 2025. So our experience, at least in the Brazilian Data Protection Authority, we have in Brazil, we have other sectoral authorities that already have their programs, their regulatory sandbox programs, like the financial sector, the transportation sector as well. But in AI, one of the first, at least the proposals are ours, with the Arbitration Authority. And we are, well, in this design phase still, and we expect that in the next year, so in 2025, we'll launch our public call for participants, and we'll have like this pilot project up and running. Yeah, I have some documents that I can share with you about the regulatory sandbox.
Okay, thank you so much.
So maybe as a last remark, Danielle, would you like to bring something? I was very interested in this bigger psychological distancing you brought us about AI and arbitration and online dispute resolution. And I was thinking about the creation of this industry of arbitration sentence challenging that we are almost having in Brazil, based on biased arbitrators and so on, and how this artificial intelligence can be used to scan the life and the background of arbitrators, but at the same time disregarding the psychological traits and the subjective aspects of a conflict of interest. Do you think it's something good, objectively good, to use this AI technology for this kind of research or not?
Hi, Karin, just as an initial remark, I just asked here ChatGPT to draft a bill to regulate AI, and it did a really good job. So I was amazed. That's of course self-regulation, which sometimes can be criticized, but it did a good job. It even created a national agency to regulate and to audit the use of AI. So that's where we stand at right now. As I said, Karin, parties must do a really good job in scanning and in profiling the arbitrator, because once the arbitrator is appointed, we know there's no turning back. And there's sometimes I see parties not doing the proper due diligence, which is a problem. So AI is just one of the things should be used to scan the arbitrator, but not the main issue here. I really think that face-to-face pre-appointment interview is really important in big disputes, so the parties can clarify what questions they have. The Charter Institute Arbitrator has a guideline on pre-appointment interview. Of course, we cannot discuss the case. We can only discuss our qualifications, and you also know that being a fellow in the Charter Institute Arbitrator, we are questioned about that. We are assessed about that, and I think the Brazilian parties, we need to evolve in the arbitration culture, and I see, of course, a lot of bad faith from the parties in the due diligence proceedings in arbitration. So sometimes they don't ask certain questions. They don't do a proper due diligence just to challenge the arbitrator in a future annulment of the arbitration award. So, and that happens, of course, if the information is public, you cannot use it in your favor afterwards. So, I've seen in my experience as a director of an arbitration center, parties arguing about academic relations. For example, I appoint you as an arbitrator, which I would love to do, Karin, someday, and people that we published a paper together. So she's biased because he's the lawyer and she's the arbitrator. And that's not, Selma Lemy says that's not economical interest. That's just common interest. So which it's really different than myself being your lawyer in some, of course, there I have an economical interest, not a common interest in academic life, in contributing to the arbitration community or whatever. So I think AI should be used to scan and to establish a profile. If I ask about you here in ChatGPT, you give me a profile, for example. Karin Klempp is a researcher in something, it gives you a certain profile. But I've done that with me, for example. and I've got different answers several times. Never like a specific. So you have to take care of where's the data coming from, actually. And it's always good, Karin, it's advice here for you to input your data. Karin, for example, you put yourself, Karin is an IP renowned researcher, so ChatGPT learns about you and uses that to answer, to reply to other people. That's useful in sometimes, of course, tell the truth, but that's useful to input some answers there. But I think AI tools are useful, but you have to use other ways. And like I said, people are being really investigated in arbitration, and especially in Brazil, the duty to disclose is even being regulated by the Supreme Court. Actually, people asked about it for it. I don't know if I hope the Supreme Court will now regulate that, and it's a key issue current. But AI is useful, but it should not be the final tool for your decision to appoint an arbitrator.
Thank you very much. Professor Zantoni wants to make a picture of us. Beatriz, Isabella, can you open your, if Celeste as well, if you want to open your cameras?
Just tell us, because I don't want to blink here. So.
Thank you. So thank you everybody for staying 2 hours here. Very, very interesting discussions. I'm very grateful. Elizaveta, your last words.
Yeah, dear participants, thank you so much. This event was very interesting for all of us. So all I understand that we are still looking for this balance between human rights and artificial intelligence. And I guess we will be looking for it for a long time. So I guess this is just the reason for all of us to gather together next year to compare the results of our research. So I hope to see all of you next year. And dear Karin and Jose, thank you so much for this amazing event.
So thank you, everybody. Have a nice day. It was really great to meet you all and discuss with you about artificial intelligence.
Thank you. Thank you so much.
Thank you, everyone. Have a good day. Bye-bye.
Legal. Ah, nossa.